Well, good afternoon, everybody. The next set of submissions I will now invite to be delivered will be those on behalf of the Cabinet Secretary for Health and Social Care as sponsor of the inquiry, and I'll hand over now to Mr. Alistair Duncan Casey. Mr. Duncan, thank you.
Thank you, sir. As your Lordship has just indicated, I do indeed appear today on behalf of the Scottish Ministers to address matters of sponsorship of the inquiry. The nature of the Minister's sponsorship role, it's touched on in paragraph 2 of the written submission that was provided by them to the inquiry on Tuesday of this week. The practical work of sponsorship is done by a sponsorship team, and it was that team who drafted the submission. The team provides sponsorship support to the inquiry, for example, assistance in securing suitable accommodation. They also have budgetary responsibility in respect of the inquiry. And perhaps I should just shorten this, sir. I detect no difference in my learned friend Mr. Dawson's description of their role than that indicated in the note from the sponsorship team. An extract of Counsel to the Inquiry's note was provided to the sponsorship team last week. This comprises sections 1 and 2 of the note, as well as part of section 9. The sponsorship team, as I've indicated, provided a written response on Tuesday, and I've been asked to appear and update that and respond to any particular or additional concerns and queries you or Council might have. And I'm grateful to my learned friend for indeed having highlighted particular issues that he would like to hear and you would like to hear, sir, more on. I consulted yesterday afternoon with those instructing me for that precise purpose, and what I really propose to do then is to deal with 3 matters. First of all, premises. Secondly, the question of confidentiality and the linked question of the management agreement. And thirdly, briefly on the question of staffing. So turning then to premises, and I want to really again break that into 3 matters. First of all, the up-to-date position in relation to Waverley Gate. Second, the availability of alternative premises. And thirdly, the way in which the sponsorship team has communicated with the inquiry and indeed to you, sir, in relation to these matters. I turn then to the up-to-date position, but before doing that, let me say at the outset, as is said in the note, it is absolutely acknowledged that the situation that has arisen here is deeply regrettable, and the knock-on effects of that, in particular the cancellation of these important hearings, is also acknowledged. It is acknowledged, sir, that the provision of safe premises is indeed ultimately the responsibility of the ministers. It is acknowledged also, as Mr. Dawson has said already today, that what has arisen is not of the inquiry's making. And it is acknowledged, sir, that the decision to postpone hearings was certainly not taken lightly and was taken responsibly. So as to the update on the current position, as you will have seen, sir, from the written submission, there was indeed proposed to be a meeting yesterday with the landlord in relation to the current position. And it was in relation to that in particular that I asked for a consultation. I was provided with a written update of where things stand following that meeting, which did indeed go ahead. And I'm now going to turn to that. I'll say at the outset, sir, that it falls short of the assurance that Council seeks in paragraph 31. In particular, I am not able to say at this point that an assurance can be given that the hearing would be able to proceed in September in Waverley Gate as premises. And if I turn to the update that I was provided with this morning, that might perhaps give some further explanation around that, and also identify the next steps that might be taken to try and get towards that assurance as quickly as possible. So what I propose to do is really just to draw your attention, sir, to the key aspects of the report that I received in relation to yesterday's meeting. It is said that there was a productive discussion with the landlord to resolve the fire safety/warrant issue. The landlord representatives confirmed that a shaft wall along the corridor wall, which bounds both inquiry spaces, and the landlord managed corridor used as a fire escape route, is required to meet the fire safety requirements and received the required warrant completion certificate. I just pause there. I think that picks up on a point that my learned friend made earlier about the focus really being on a completion certificate. And again, also just identifies that the issue that arises here is an issue to do with fire safety regulations and compliance with those. I read on. The landlord advised that there is not requirement for this work to be carried out on the wall, which separates the two inquiry spaces. The Scottish Government team were advised that City of Edinburgh Council confirmed to the landlord that a shaft wall along the full corridor would be acceptable to them to sign off the building warrant completion certificate for the area. So, to some extent, a positive development, sir. I read on. The landlord advised it is their plan to appoint external contractors today to develop the detailed design and specification required for approval of works and ultimately the warrant. There has been high-level discussion only so far. As the recent new owner of the building, they do not have a standing team of advisors and contractors in place yet, but are proceeding to put a team in place at once. An indicative timeline will be developed as part of this work, and a number of steps are then set out as being the steps that would be on that timeline. First of all, being design and specification for the shaft wall, and also an indication of timescales as regards the completion of those works.
Sorry,
Advice
Mr. Duncan, I wonder if I could just come in on one particular point. Not everybody will necessarily be up to speed with modern building descriptions, but for the benefit of those watching the proceedings, can you give me a brief rehearsal of what is meant by a shaft wall and what in practical terms that should look like to those who might be interested to know?
My understanding, and perhaps you'd emphasise that word, sir, is that essentially what would arise is, first of all, I think the creation of studs, so something to hold the wall in place, and I think the wall would be made of concrete, and there would be a sort of space in between it to allow ventilation. That really is about as much as I know, sir. If I'm able to improve on that before the end of the day, I will certainly let your lordship know.
All right, thank you.
I was just walking through very briefly, sir, the steps that are to be taken. So there will be advice provided to the ministers on the approach to be taken to the works. An important issue, for example, will a decant of the area be required, or is it actually possible to do the works with people on site? The specification for works will need to be agreed, the costs of the works will need to be agreed, and a full project timetable to be confirmed. And along with that, and I imagine this would be in parallel, engagement with the City of Edinburgh Council to ensure the proposed design and specification would indeed meet the need for the warrant. So beyond that description, so just one or two further comments that I received in my update. The landlord representatives are due to meet with the contractors who will be drawing up the design and the specification this week, and will report back to ministers after that, including in relation to the indicative timescales. The finalised timeframe will not be available until a works contractor is appointed, so I'll come back to that in a moment. At the meeting, the Minister stressed the critical importance of this work being completed at pace and to the correct specification for the inquiries and the families who have been impacted, and that hearings have had to be cancelled and that there are further hearings planned for later this year. The landlord representatives recognised the sensitivity and time pressure of this work and have confirmed that they are anxious to secure the solution promptly. Now, I said there was one point I was going to come back to, sir, and that is about the appointment of contractors. There seems to be a two-stage process to this. That first of all, there's a contractor being appointed in relation to the design and specification for the works. That's in the process of happening, as I understand it. And that in addition to that, there will be an appointment of a contractor to carry out the works. Now, it may be it's the same contractor. I don't know. That's perhaps a point that that could usefully be clarified. I mentioned another matter, sir, in the timeline, and that is the working in parallel with City of Edinburgh Council. What I've been told, and this was apparently said yesterday, that the ministers will contact City of Edinburgh Council to discuss further following the meeting with the landlord, and to engage with them and to make sure that they are on target, or rather that this proposal is on target for something that will indeed meet with approval. Sir, I said at the outset of this that I absolutely recognise, as do those who instruct me, that this falls short of the assurance that is sought through Council's note. And I suspect for consideration then is reporting to you, sir, and to the inquiry as regards the next steps on all of this. And it may be that that's a discussion that might be something Mr. Dawson wants to come back on today. I accept, but it could be that those instructing me could simply provide a written indication confirming what I've just said, but also setting out exactly how the reporting on this is to proceed going forward, in order that as expeditious a solution can be achieved as possible. Sir, unless there's anything further on the up-to-date position, I want to go on and deal with the question of alternative premises, and then also to deal with what has been said in relation to the communication with yourself and with the inquiry.
Yes, please do.
Thank you, sir. In relation to alternative premises, I think Mr. Dawson's description of the way in which the note from the sponsor team has been drafted is fair. I think it is ambiguous. And can I just be clear that it is not being suggested that your lordship or the secretary have been offered a ready-to-use premises which they can simply walk into. I think this is probably an issue that would benefit from being addressed after this hearing in writing. In other words, I have suggested to those instructing me that they simply write to your lordship and to your lordship's secretary, and to set out exactly what the next steps are to be in relation to what we might call Plan B. And my broad understanding of things, sir, is that ultimately, self-evidently, it's a matter for your lordship as to what suitable accommodation is and is not. But there are obviously the parallel issues of exactly what the practical steps are as regards securing any of these alternatives. And by these alternatives, I'm speaking principally about the suite currently occupied by the Scottish Child Abuse Inquiry. So essentially, sir, I simply propose that after this hearing, the sponsor team provide in writing, along with the update that I've already referred to, a clear proposal of what would be required in relation to consideration of any alternative premises.
Mr. Duncan, I think that would certainly be helpful if that is a proposal that is yet to be generated in sufficient detail to make sense to those who are interested in knowing what that plan might look like, but obviously consistent with the principles that we adopt in the inquiry about being open with everyone about matters of this kind and many others, then I think you could take it that if there is information that will in due course be shared, that's something that will be shared by me more broadly so that everybody has a clear steer on what is happening.
I would need to take instructions on that, obviously, sir, but I would imagine that that understanding would be would already have been recognised by those instructing me. Really what I'm proposing is the amplification and the supplementing of what I have already said today in public. So I think what your lordship is proposing would be consistent with that. I turn then to the question then of communication with the inquiry and with the chair, and perhaps just in doing that, maybe just in relation to the topic that I've just been dealing with, I think there's been an aspect of perhaps communication not going terribly well in relation to the alternative premises idea, or at least perhaps people being at cross purposes to some extent. But I move then to the topic of communication with the inquiry and with the chair. And can I just say at the outset, sir, that the overall tenor of what my learned friend has said about the concerns and criticisms and deficiencies in the reporting to you, sir, and to the inquiry, that description would be accepted and it would not be taken issue with. And so in anything I'm about to say, it should not be thought that there is an intention to try and say otherwise. I don't propose to say very much about the timeline other than in relation to two matters. My learned friend has asked the question about whether there should have been an understanding of this issue on the part of ministers, on the part of Scottish Government prior to December of last year. That's not something I'm in a position to deal with today, sir. And if it is a matter that the inquiry would want to know more about, I think some further investigation would need to be done on that. My learned friend has also, under reference to the timeline set out on page 3 of the note provided by the sponsor team, he has in particular looked at the period between the 12th of January and the 23rd of March. And I might just say a wee bit more about that, but it really is only to add some detail. I repeat what I said at the outset of this discussion. In particular, as my learned friend has said, your lordship, of course, wrote to the sponsor team on the 6th of February, raising a number of issues, including the one we're currently discussing. I think in response to that, the sponsorship team appears to have proposed a meeting with the inquiry team. And I might also mention, sir, that there was a change in personnel within the sponsorship team around this team, with the current the current team being in post, or the whole team being in post from the end of February. As they saw it, there was also an absence of clarity about the precise nature of the issue that they were dealing with. But that again doesn't in any way contradict what I said earlier. It's accepted that the communication responsibility sat with them. There appear to have been calls and/or meetings with your lordship's secretary in early March, and there was eventually one, I think, on the 24th of March, which led to the decision to have the meeting on the 16th of April. There's the other confounding issue at that point of the change of ownership coming to light, and a new landlord who's not cited on any of this being in post. It is to be emphasised, I think, that when your lordship did eventually get a written reply to his letter on the 1st of April 2026, That was accompanied with an apology for the delay in responding. And that was an apology that I am to repeat today. Council has expressed frustration with the level of communication from the sponsorship team. And as I've indicated, those instructing me take no issue with that. And indeed, I think I understand that to have been acknowledged at the meeting on the 16th of April. So I repeat, as I've said a moment ago, that the apology is repeated and the frustration is acknowledged and regretted. There may be a variety of reasons behind the scenes for this, but as I've said, the sponsorship team accepts that it has responsibility ultimately for these matters, and that communication was not effective. There is an undertaking to do better. And indeed, my understanding is that following the meeting on the 16th of April, one of the steps that was taken was a reporting protocol to go between the sponsor team and the inquiry team. And I think that is now underway. But I think beyond that, sir, I think all I can really say on their behalf is to give an undertaking that they are resolved to do everything they can to try and reach a solution to the current problem as soon as possible, and to communicate with your lordship and his team effectively in relation to that. Sir, those are really, that really is all I have to say in relation to the question of the premises, unless there's anything additionally that you would like to hear from me just now on, sir.
I think not at this stage, Mr. Duncan. It may be that Mr. Dawson wishes to come back, but there's nothing more from me at the moment, so I'm happy for you to proceed.
Thank you very much. I move then to the second topic, the confidentiality, the question of confidentiality and the linked issue of the management agreement. I intend to take this fairly briefly for reasons that will become clear in a moment. As my learned friend Mr. Dawson has already indicated in the written submission from the sponsor team, it is said that subject to outstanding issues to do with confidentiality, the management agreement is agreed by the sponsorship team. I'm somewhat unclear as to any suggestion that the agreement hasn't been read or properly considered, but perhaps for more practical purposes, what my learned friend said about that has been heard, and it is understood that it requires to be read and indeed understood. And my learned friend has helpfully raised at least one issue in relation to that, the issue of FOI, and that will be considered further, I'm sure. On the issue of confidentiality and the outstanding discussions on that, that is a matter in relation to which I've pressed for some further explanation, and I am told that there is to be a written explanation of the perceived complexities and concerns, and also the proposed solution in relation to that. I have pushed for an indication of what the timescale is for that explanation, as indeed have the sponsor team. And what I'm told is that the matter is being considered as a matter of urgency. And I think, certainly, sorry, I think you can rest assured that the sponsor team and the solicitors involved in instructing me today certainly understand the urgency in getting answers and bringing a conclusion to matters such as this. The final topic, sir, then is the question of staffing. I personally am at something of a disadvantage here in that I haven't seen the totality of my learned friend's note. I've obviously heard what he has said today. I think it is possible that there are different understandings, at least in relation to the question of vacancies on each side. My understanding is that that was a matter that was going to be addressed within the reporting tracker that I referred to a moment ago. So Those instructing me, at least as matters currently stand, sir, are not clear what more the inquiry team or you, sir, would want from them on this topic. So I don't really have more I can usefully say on that topic at this point. Sir, that is all I have to say. And other than repeating again the deeply regrettable situation that the inquiry has found itself in and the impact on those involved in the inquiry, I think I would just simply conclude my submission at this point.
Very well. Thank you very much, Mr. Duncan, for confirming these matters. It's appreciated that you took the time to do so. Thank you.
Thank you, sir.
I think that given the time, it would be expedient just to move straight on now to the next programmed set of submissions without a break, and we will have a break after what follows. That means that I'm now going to invite Ms. Doherty, KC, to address the hearing in connection with her submissions on behalf of NHS Tayside. Ms. Doherty.
Thank you. Sir, I appear on behalf of NHS Tayside along with Kat McQueen and instructed by Tracy Turnbull of the Central Legal Office. NHS Tayside is grateful to the inquiry for the opportunity to respond in writing and orally to counsel to the inquiry's note for this procedural hearing. I propose to read out the submission on behalf of NHS Tayside, which was provided to the inquiry on Tuesday morning, and to make some additional comments relevant to the matters contained in it. I will then briefly comment on the submission by the Independent Clinical Review, the ICR, which was shared on Tuesday afternoon. 5 matters raised in counsel to the inquiry's note are addressed in the submission in 5 separate chapters. NHS Tayside's position regarding representation and support to current and former employees, trauma-informed policy, lessons learned, preparations for Section 1 hearings, and the instruction of expert witnesses. Turning to Chapter 1, NHS Tayside's position regarding representation and support to current and former employees. NHS Tayside's legal representation in this inquiry and the support available to current and former employees are matters which NHS Tayside brought to the attention of the inquiry from an early stage in proceedings. It has sought to set out its position in submissions to the inquiry, published on the inquiry website, dated 4th September 2025, 13th November 2025, and 21st November 2025, and in its submission to the inquiry dated 3rd December 2025, which counsel to the inquiry circulated to core participants last week, 5 months after receipt. That submission was published on the inquiry website on 18th December 2025, but so far as NHS Tayside is aware, with no notification given to core participants at that time. There has also been more recent correspondence on this matter between me, as counsel for NHS Tayside, and counsel to the inquiry in March and April of this year. Sir, I would point out that in counsel to the inquiry's note at paragraph 104, he states that the inquiry is keen that this matter of support to current and former employees should be resolved as soon as possible, as is NHS Tayside. It is respectfully suggested, sir, that whilst the inquiry may now be keen to resolve this matter as soon as possible, until recently there was a lack of any substantive response or discussion on the matter following receipt by the inquiry of NHS Tayside's submission dated 3rd December 2025, which was made to clarify the 2 matters raised by counsel to the inquiry at the opening statements hearing. Receipt of that NHS Tayside submission was formally acknowledged by the inquiry team on 5th December 2025, who stated that it would be considered. NHS Tayside solicitor sent a follow-up email to the inquiry team on 22nd January 2026, asking whether there was any outcome from the inquiry's consideration. That was met with an email response on 23rd January 2026 that the matter was still under consideration. Another email on 12th March 2026 from NHS Tayside solicitor asking for any outcome from the inquiry's consideration did not receive a response. On 27th March, I asked Counsel to the Inquiry for a response to the submission dated 3rd December 2025. That led to correspondence between me and Counsel to the Inquiry, with responses to his further queries being provided on the 31st of March and the 2nd of April. On the 16th of April, I asked Counsel to the Inquiry for an update and offered a meeting between Counsel and solicitors if there were further queries. On the 23rd of April, so 3 weeks ago, I provided further information to Counsel to the Inquiry, and I specifically asked that Counsel to the Inquiry come back to me in advance of the procedural hearing if there were further questions about what was being proposed by NHS Tayside. I repeated the offer of a meeting if that would assist to progress matters. Rather than coming back to me or to NHS Tayside's solicitor, Counsel to the Inquiry has raised a substantial number of queries in his note for these to be addressed at today's procedural hearing. Counsel to the Inquiry has on a number of occasions referred to this inquiry having a collaborative approach, and the inquiry's own statement on protocols and principles lists cooperation as one of the key principles for the conduct of the inquiry's work. In my submission, it would have been more productive to have raised these queries and had them answered in advance of this procedural hearing. It appears from the timeline that months elapsed when little or no consideration was given to this issue by the inquiry team. Whilst in late March and April, Counsel to the Inquiry did re-engage with this issue, it is disappointing that the inquiry has chosen not to work with us prior to this hearing to receive the answers still sought. And of course, this inquiry is an inquisitorial rather than an adversarial process. NHS Tayside has been keen to ensure from the outset that any current or former employees who are required to provide evidence to this inquiry are supported in doing so. It reiterates to its current and former employees that support is available to them. In previous submissions, it has explained the pastoral and practical or administrative support available and how that can be accessed by current or former employees. It has also set out its proposed legal support, and that term is used to describe support by a solicitor in the preparation of a witness's evidence. In this submission, NHS Tayside seeks to set out again its position and to clarify certain matters raised by Counsel to the Inquiry's note. First, by advising the inquiry of its proposed position on the issue of legal support to current and former employees, NHS Tayside is not seeking to make an application to the Chair for an endorsement of its plans. Rather, it was felt appropriate to raise this matter with the inquiry at an early stage in accordance with the inquiry's collaborative approach, which NHS Tayside fully adopts. NHS Tayside has sought to be open and transparent about its approach. The detail of the delivery of its proposed support has evolved in consideration of and response to certain of Counsel to the Inquiry's queries. As has been made clear in previous submissions, the solicitors within the Central Legal Office, the CLO, are instructed by health boards in NHS Scotland to provide those public bodies with legal representation and advice. The solicitors within the CLO are not instructed to and do not represent individual employees, whether current or former. NHS Scotland health boards do not offer to provide legal advice or legal representation to their current or former employees through their instructed solicitors. In this inquiry, NHS Tayside's legal team, both those within the CLO and Council, are its recognised legal representatives in terms of Rule 5 of the Inquiry Scotland Rules 2007. That legal team is not the recognised legal representative of any individual in this inquiry. That legal team will provide support in the preparation of corporate witness statements. Support by that legal team to witnesses who are representatives of the public body NHS Tayside in the preparation of corporate witness statements is consistent with the legal team's role as recognised legal representatives of NHS Tayside. Legal support, and again, this means support by a solicitor in the preparation of witness evidence, is always available to NHS Tayside's current and former employees who are witnesses in proceedings such as public inquiries. This support, however, does not involve legal advice to or legal representation of the individual witness. This is the approach adopted by health boards across NHS Scotland. The approach proposed by NHS Tayside in terms of the support it can offer to its current and former employees in this inquiry is not novel, although for the reasons given below, the appointment of a solicitor separate from a health board's legal team in an inquiry to provide such support is not usually required. That is the only difference in the support being offered. The actual content of the support being offered will be similar to that usually provided to witnesses by legal teams acting for NHS Scotland health boards in an inquiry. It must be borne in mind that not all witnesses require to be individually represented in an inquiry. This is clear from the inquiry's own protocol on approach to evidence and written statements and protocol on public hearings. Often in inquiries, there will be no reason for an individual employee of a health board to require to obtain their own legal advice or representation, particularly where they will not be subjected to personal criticism by the inquiry. In such circumstances, an individual current or former employee who is a witness in an inquiry may simply benefit from pastoral and practical or administrative support, including from a solicitor instructed by the health board in the preparation and giving of their evidence with no legal advice or representation being required. Such support is clearly distinct from legal advice or representation and therefore can be offered by health boards and provided by the CLO. This has always been the position. The reason for raising with the inquiry the matter of legal support, and by that I mean support by a solicitor, for individual witnesses at an early stage, was because it was recognised that there may be a concern by former patients of Mr Eljamel that NHS Tayside and its legal team in this inquiry would be too closely involved in the preparation of evidence of witnesses who are giving evidence to the inquiry, not as representatives of NHS Tayside, so senior leaders currently in post speaking on behalf of the board, but as individuals in their own right. NHS Tayside has therefore been conscious to ensure that the nature of the support that it would usually provide to those individuals in connection with the preparation of their evidence remains arm's length. Adopting a collaborative approach, it has been keen to ensure that its proposed provision of support to witnesses is acceptable to the inquiry and the core participants, particularly the former patients of Mr Eljamel. Given the wish to ensure that the support given to witnesses is demonstrably at arm's length, an approach slightly different to that usually taken has been proposed in this inquiry. It is suggested that a solicitor of the CLO who is not part of NHS Tayside's legal team in this inquiry should provide that pastoral and practical or administrative support to individual current or former employees who wish that assistance in the preparation of their evidence to the inquiry. This would ensure that NHS Tayside and its legal team in this inquiry remain at arm's length from the evidence of those individual current and former employees who are giving evidence to the inquiry in their own right, rather than as representatives of NHS Tayside. It is hoped that this proposed approach is satisfactory and will alleviate any concerns that former patients may otherwise have. NHS Tayside would therefore instruct a senior solicitor at the CLO, separate to its legal team in this inquiry, for the particular task of assisting witnesses in the preparation of their evidence. This solicitor would not be a recognised legal representative of NHS Tayside in this inquiry. NHS Tayside would instruct and fund this support, but otherwise would have no involvement in the support given by the solicitor. The solicitor would not disclose any information or document included with or within the request or notice or the response to NHS Tayside or its recognised legal representatives. An information barrier would be in place within the CLO. The role of the project management officer, who would be the witness's first point of contact, would simply be one of gatekeeping. The project management officer would not need to be provided with any information or document included with or within the request or notice, as their role is simply to signpost the witness to the solicitor at the CLO. The solicitor would support the individual witnesses by explaining the general process of giving evidence to the inquiry and by reviewing the witness's statement to check that it answers the questions being asked and is properly formatted. The purpose of this role is to support the witness through the inquiry process and to assist them in providing their best evidence to the inquiry, to the benefit of all involved. This is similar to the role performed by solicitors appointed by health boards in other inquiries who support but do not represent individual witnesses. If it appears that there may be personal criticism, which ought to be evident at an early stage, the solicitor would signpost the individual to seek their own independent representation. To enable an individual recipient of a Rule 8 request or Section 21 notice to receive support through such a solicitor in connection with the preparation of their evidence, it is suggested that under paragraph 17, subsection G, of the first order by the chair of the inquiry, the chair, you sir, could provide written agreement that the individual recipient can share the request for evidence with the named CLO solicitor tasked with offering that support. Arrangements could be made for that solicitor to sign the inquiry's confidentiality undertaking. In accordance with paragraph 27 of the inquiry's protocol on approach to evidence and witness statements, an evidence request directed to an individual witness providing evidence in their own right, rather than on behalf of NHS Tayside, ought to be sent directly to that individual. NHS Tayside will seek to assist the inquiry in identifying the location of potential witnesses who are current or former employees of the board, if so required. As the proposed approach is now for a solicitor separate from NHS Tayside's legal team to provide the support to individual witnesses in connection with the preparation of their evidence, a conflict check would no longer be necessary. In those cases where current or former employees would benefit from independent legal advice and representation, NHS Tayside understands that this is likely to be offered by medical defence unions, medical defence organisations, and this ought to include cases where former employees are not currently members of such an organisation, but nevertheless held such membership at the relevant time. While this is NHS Tayside's understanding of the position, the inquiry will require to confirm the position with the relevant organisations. NHS Tayside would not wish any current or former employees who have good reason to seek independent legal representation, but who do not have current or former membership of a medical defence or similar organisation, to be precluded from obtaining that representation where required. In such circumstances, NHS Tayside would be willing to consider potential funding arrangements for legal representation for such individuals on a case-by-case basis, mindful that such funding would be from public funds. Turning now to Chapter 2 of my submission, sir, and the trauma-informed policy. NHS Tayside welcomes that the inquiry will implement a trauma-informed policy. There is, however, an indication at paragraph 44 of Counsel to the Inquiry's note that this policy will not apply to everyone. It is respectfully submitted that any such policy of the inquiry ought to apply equally to all involved. The policy itself will no doubt set out the approach to be taken, dependent on an individual's circumstances. It is important to bear in mind that participation in an inquiry can be traumatising for a range of individuals and for a variety of reasons, which may not always be immediately apparent. Turning now to Chapter 3 and lessons learned. NHS Tayside notes from paragraph 71, subsection H of Council to Inquiries note that in future, the inquiry will endeavour to provide witnesses and their recognised legal representatives with better advance notice as to when they are likely to receive requests and the likely timescale, and that it is intended for discussions to take place between the solicitor to the inquiry and recognised legal representatives to improve ways of doing things going forward. NHS Tayside welcomes this, given difficulties to date. And for example, the timescale for the draft response to the first Rule 8 request issued to NHS Tayside was not realistic, given that its response required input from 8 senior executives. Even now, there continues to be a lack of discussion about what is realistic. On Monday afternoon, so that's Monday the 11th of May, the inquiry team returned NHS Tayside's lengthy draft response with suggested changes to be made to be completed by close of business tomorrow, Friday, 15th May. That this demand be issued without discussion with such a short timescale in a week when NHS Tayside and its legal team are involved in preparing a written response to CTI's note and considering the written response of other core participants and attending the procedural hearing today is disappointing. NHS Tayside hopes to work collaboratively with the inquiry for realistic deadlines to be set in relation to any future requests for evidence so that these can be achieved. It is also noted that the time allowed for responses to Council to the Inquiry's note for this procedural hearing was short, effectively 2 working days. This was very demanding as a timescale, given the need for input from NHS Tayside and its legal team. Going forward, it is hoped that more reasonable timescales are set. And separately, NHS Tayside also hopes that the communication with the inquiry solicitor team will be improved. In March and April of this year, NHS Tayside solicitor requested meetings with the inquiry's solicitor without any success. Turning now to Chapter 4 and the preparation for the Section 1's hearings. It is noted that 1 additional week has been assigned for the hearings, which are planned to take place in September this year. At paragraph 56 of Council to Inquiry's note, he sets out matters on which evidence will be heard in the Section 1 hearings and refers to the provisional outline of scope for Section 1 hearings previously published and dated October 2025. And we are grateful for the clarification given today by Council to the Inquiry on the matters to be covered in the Section 1 hearings. It is noted from paragraphs 76 and 77 of Council to Inquiry's note that the inquiry intends to disclose Section 1 materials to core participants on a rolling basis and further in advance of the Section 1 hearings than might have been possible had the hearings proceeded in April this year, with a target now of the 22nd of June this year as the date by which it is hoped the bulk of the Section 1 statements and materials will be disclosed to core participants. NHS Tayside welcomes this approach. In order for NHS Tayside to efficiently and effectively prepare for the Section 1 hearings, given the anticipated large volume of documents, the inquiry is respectfully invited to commence disclosure as early as possible and on a rolling basis. As the inquiry were initially preparing for Section 1 hearings to commence in April, it is hoped that the inquiry team will be well placed imminently to disclose to core participants a number of the statements and materials. Paragraph 78 of Council to the Inquiry's note indicates that in the week commencing 6 July 2026, core participants will receive a draft witness list and timetable indicating the witnesses whom the inquiry intends to call to give evidence at the Section 1 hearings. It is respectfully requested that a draft list of witnesses is intimated to core participants at an earlier date. It is important that any individuals whom the inquiry intends to call to give evidence has notice of this as soon as possible so that they can make arrangements to ensure their availability to attend. It is anticipated that any witness from NHS Tayside called to give evidence at the Section 1 hearings on behalf of the board will likely hold a senior leadership position and will therefore have significant diary commitments. As it is understood that the inquiry's preparations for the Section 1 hearings due to commence in April were well underway, and presumably included a draft witness list and timetable, it is hoped that the inquiry will be in a position to provide a draft witness list and timetable in very early course. Chapter 5 of my submission relates to the instruction of expert witnesses. NHS Tayside welcomes the inquiry's intimation now of the identity of the neurosurgical experts and the medical ethics experts who have been instructed to provide reports. It is, however, noted that intimation has not yet been provided as to the identity of the 2 experts already instructed to prepare reports in respect of healthcare administration, and the inquiry is respectfully invited to provide that information now. The inquiry's own expert evidence protocol states at paragraph 18 that the identity of expert witnesses whom the inquiry intends to instruct will be intimated to core participants before the experts are instructed. This does not appear to have been complied with by the inquiry, given that core participants have not received any intimation of any expert witnesses to be instructed in advance of their instruction. In the future, the inquiry is respectfully invited to intimate the identity of all expert witnesses to core participants in advance of them being instructed in accordance with its own protocol. Sir, having concluded the submission in response to Council to the inquiry's note, I would now like to make a couple of points in relation to the independent clinical review submissions. First, at page 2, it is stated that the independent clinical review has procured confidential and independent psychological support for former patients via the Association of Clinical Psychologists UK. In fact, as has been stated in previous submissions and at the oral statements hearing, the contract is between NHS Tayside and the Association of Clinical Psychologists UK for these independent psychological support services, and it is NHS Tayside which is funding these services. This is mentioned again, as NHS Tayside is very aware of the distrust that some feel towards it. The support offered is, however, wholly independent of NHS Tayside. And second, at page 3, it is stated that the independent clinical review has set up a panel of 29 neurosurgical experts. Does the independent clinical review intend to publish the names of these experts on its website? It would be useful to know the identity of these experts now, as these expert reports will be relied upon by the inquiry, as per the Memorandum of Understanding entered into between the inquiry and the independent clinical review. So, thank you, sir. That concludes my submission, unless there's anything else I can
No, thank you very
with at
much,
this
Ms
time.
Doherty. It's very helpful. Well, we now reach a point in the agenda where I intend to call a 15-minute break. By my reckoning, it's just before 10 to 3, so we will resume the hearing again at 3:05, where you will hear initially from Laura Thompson, representing the Scottish ministers as core participants. So thank you. 3:05. Right, good afternoon again, everybody. I'm now going to invite Ms. Laura Thompson to deliver her submissions on behalf of the Scottish Ministers as core participants in the inquiry. Ms. Thompson.
Thank you, sir. The Scottish Ministers welcome the opportunity to make this submission, which provides a response to matters arising from the note issued by Senior Counsel to the inquiry on the 7th of May. For the avoidance of doubt, as was the case at the last procedural hearing, these submissions are provided for the Scottish Ministers in their role as core participant and material providers to the inquiry. The authors of these submissions have no role in respect of the Scottish Minister's sponsorship of the inquiry. Turning then to the Minister's response to particular points raised by Counsel to the inquiry in his note, and dealing firstly with preparatory work to support disclosure of information to the inquiry. Since the commencement of the inquiry, the Scottish Ministers have carried out significant preparatory work with a view to assisting the inquiry in making efficient progress in gathering evidence relevant to its terms of reference and list of issues. I would like to set out the preparatory work that has been undertaken in anticipation of compliance with the inquiry's subsequently published protocols and to address many of the issues identified by Senior Counsel's note at paragraphs 56 to 61. The process of identifying relevant documents formally began on the 11th of April 2025, following the establishment of the inquiry on April 3rd, when the terms of reference were announced. The Scottish Ministers were keen to commence that process prior to any formal request from the inquiry, in order to ensure that they were well prepared to respond to requests for documents from the inquiry when such requests were received. Search terms were developed to capture all documentation of potential relevance to the inquiry's terms of reference and list of issues. These search terms were used to interrogate the Scottish Government's various corporate electronic systems, including ERDM, the main records repository, and its predecessor G Drive, Objective Connect, the Microsoft Outlook folders of past and present members of staff, OneDrive and C Drive folders, and WhatsApp records. Legacy paper files held by the Scottish Government and the National Records of Scotland were also searched. In addition, a search and retrieval exercise was commissioned within the network of health and social care directors and their deputy directors. These various searches identified circa 400,000 individual documents of potential relevance to the inquiry. These documents were screened for relevance, and many duplicate documents were sifted out. This refinement exercise reduced the number of relevant documents to around 19,000. The Scottish Ministers instructed their legal representatives to review these documents for relevancy and duplication, as well as checking for any potential issues of privilege or confidentiality, such as data law compliance. This initial exercise is now largely complete, reducing the number of relevant documents further to around 17,000. This process has involved significant work from an extended team of 26 solicitors in order to make progress at pace. The core legal team are now undertaking a further detailed review of documents flagged as part of the initial screening, in order to more fully consider any issues of privilege or confidentiality that might require to be flagged to the inquiry team as part of anticipated document disclosure exercises. The legal team, in conjunction with the Scottish Government's inquiry response team, are also developing a system of indexing and organisation, such as to ensure that documentation can be disclosed in an organised and user-friendly format. Whilst that involves additional work for the Scottish Ministers and takes additional time, it is anticipated that this will save resource for the inquiry. The Scottish Ministers are keen to ensure that the inquiry does not receive large volumes of disorganised papers as part of any disclosure exercise. A total of 172 documents were identified as directly relevant to the inquiry's Section 1 hearings and were submitted on the 9th of March 2026 in response to the inquiry's Rule 8 request. The Scottish Ministers would welcome discussions with the inquiry team as to the most appropriate means and timing for disclosure of the remaining documents to the inquiry. For the avoidance of doubt, the Scottish Minister's approach to documentation review has been and will continue to be iterative. Upon receipt of the list of issues from the inquiry, the Scottish Ministers carried out fresh searches to ensure that there were no additional documents that would fall within the scope of these issues which had not been returned during the initial searches. Given the breadth of the original searches, nothing new has arisen. Should the list of issues be further updated or amended, further searches will be conducted to ensure that the process of identifying all documents of relevance to the inquiry remains as robust as possible. Rule 8 process. As outlined at paragraph 59 of Counsel to the Inquiry's note, on the 10th of November 2025, the inquiry served a Rule 8 notice upon the Scottish Ministers, requesting the preparation of a witness statement addressing a variety of matters. A witness statement signed by Caroline Lamb, the Director General for Health and Social Care within the Scottish Government, was submitted to the inquiry on the 9th of March 2026. The statement amounts to more than 23,000 words and is 74 pages long. It provides an explanation of, inter alia, the corporate governance structure of the Scottish Government, the various responsibilities held by the Scottish Ministers in respect of the management and regulation of healthcare in Scotland, the relationship that the Scottish Ministers have and have had over the relevant period with other relevant parties, their involvement in respect of the issues arising from Mr. Eljamel's clinical practice over the relevant period, the Scottish Minister's role in respect of previous reviews and investigations regarding Mr. Eljamel's practice, and the process leading up to the establishment of this inquiry. The documents appended to and produced with Ms. Lamb's witness statement, being the 172 documents referenced earlier in this submission, do not form the full body of documents held by the Scottish Ministers that may be of relevance to the inquiry. The Scottish Ministers are grateful for the confirmation they received from the inquiry during the Rule 8 process that disclosure should, at that time, be restricted to provision only of the documents directly relevant to Ms. Lamb's statement and the inquiry's Section 1 hearings. In particular, the Scottish Ministers welcomed the inquiry's recognition during the Rule 8 process, as has also been highlighted at page 37 of Counsel to the Inquiry's note, of the importance of compliance with data protection obligations. The Scottish Ministers are keen to explore further with the inquiry the potential for future use of Section 21 notices and blanket restriction orders as tools to address both the obligations of the Scottish Ministers and the inquiry and facilitate full document disclosure to the inquiry. Hearing venue issues and resourcing of the inquiry. The issues identified from paragraphs 19 to 39 of Senior Counsel's note have been responded to separately by the sponsored team. Trauma-informed policy. The Scottish Ministers welcome the inquiry's explanation as to the trauma-informed approach it will take to its hearings and commends all the steps taken by the inquiry to ensure the patient group are able to fully contribute to the work of the inquiry. Future hearing dates. The Scottish Ministers understand from paragraph 74 of Counsel to the Inquiry's note that Section 1 hearings are now due to take place in September. The Scottish Ministers are grateful for the further clarification provided in this respect. They welcome the indication given at paragraph 76 of the note that disclosure relevant to these hearings will be on a rolling basis and take place further in advance of the hearings than originally anticipated. They also welcome the commitment set out in paragraph 71H of Council's note that, going forward, the inquiry will endeavour to provide better advance notice of the likely timings of requests for disclosure of documents by material providers. Indicative timings will enable the Scottish Ministers and their legal team to ensure that sufficient resource is available to respond to such requests when received within the timescales set by the inquiry. Detailed forward planning is essential to ensure that all core participants can participate fully in the work of the inquiry and contribute to the best of their ability. The Scottish Ministers also welcome the recognition from Counsel to the inquiry, again at paragraph 71H of his note, that reasonable periods of notice in respect of timetabling would also be of benefit to all engaging with the inquiry. The inquiry will note from the Scottish Minister's opening statement that many of the witnesses who are likely to provide relevant evidence to the inquiry are no longer in post. Some have retired or have moved on to other employment. Those who remain in post are subject to a large number of other professional commitments. In both instances, a reasonable period of notice would be of assistance in ensuring that the witness is able to put aside sufficient time to assist the inquiry to the best of their ability. Such notice will, of course, also be mutually beneficial to the witness and the inquiry in ensuring that the one substantive witness statement review process outlined in Counsel to the inquiry's note may be effective. The Scottish Ministers are keen to engage with the inquiry on a regular basis in relation to forward planning and to discuss realistic timescales for any preparatory work that will be required. The Scottish Minister's legal team are keen to take up the offer of a meeting with the inquiry's solicitor to discuss such matters, again as set out at paragraph 71H of Counsel's note, and look forward to such a meeting being scheduled in early course. In that context, they note the proposed timetable for witness scheduling as set out in paragraph 78. The 2-week period proposed falls at the beginning of the school summer holidays. It is anticipated that this will cause administrative difficulties in obtaining the necessary information and instructions. Earlier intimation would be welcome if achievable. Confidentiality undertakings. In relation to the call made at paragraph 37 of Counsel to the inquiry's note, the Scottish Ministers would note the following. On the 4th of March 2026, the inquiry solicitor wrote to Harper MacLeod with a style confidentiality undertaking for core participants and a confidentiality undertaking for designated legal representatives, requesting that they be signed by those who will have access to confidential material in either a core participant capacity, a material provider capacity, or in both capacities. On the 18th of March, access was provided to Harper MacLeod by the inquiry to an Objective Connect space, where the confidentiality undertakings for the relevant solicitors from Harper MacLeod, who act on behalf of the Ministers, and by senior and junior counsel, were uploaded that day. Signed confidentiality undertakings for the Scottish Ministers' Inquiry Response Team were provided to the inquiry on the 21st of April. The Scottish Ministers' Inquiry Response Team also coordinated an exercise of identifying and requesting that confidentiality undertakings be signed by those who will in future likely have access to confidential material related to the inquiry. A further 56 confidentiality undertakings for a wider cohort of individuals within the Scottish Government who may in future come into contact with documents shared by the inquiry as it moves to that phase of its work were uploaded to the Inquiry Objective Connect space over the course of the 6th and 7th of May, with updates provided thereon to the inquiry solicitor. The inquiry was, as at 2 p.m. on the 7th of May, in possession of 79 confidentiality undertakings. A further 2 confidentiality undertakings for Scottish Government staff were submitted to the inquiry on the 8th of May. The Scottish Ministers regret the delay in the provision to the inquiry of some signed confidentiality undertakings. As the inquiry solicitor was also advised on the 7th of May, further undertakings will be submitted once a new government has been formed, and the need for any additional undertakings will be kept under review as the work of the inquiry progresses, both in relation to personnel changes and any additions resulting from particular information provided by the inquiry or requested by the inquiry. The exercise outlined, however, did not extend to include those staff who provide shared services to the inquiry, such as IT services. That will be addressed through the sponsor team submission. In conclusion, sir, the Scottish Ministers look forward to attending today's hearing and contributing to the procedural matters under discussion today. They wish to take this opportunity to restate their commitment to supporting the important work of the inquiry in every way that they can. Unless I can assist you further, sir, that concludes the submission on behalf of the Scottish Ministers as core participants to this inquiry.
Very well. Thank you very much, Ms Thompson. Can I now invite Mr Callender of Morton Fraser McRoberts to deliver his submissions. He appears this afternoon on behalf of the Independent Clinical Review. Mr Callender, thank you.
Thank you, my Lord. I'm here on behalf of the Chair of the Independent Clinical Review, Professor Stephen Wigmore. The Chair welcomes this opportunity to update parties on the work of the ICR. This is detailed in the written submissions, which will be published following the hearing. I will address the inquiry on the substantial progress made by the ICR since the previous hearing, the approach the ICR is taking to delivering its role and working together with the other parties, the timetable for the production of clinical reviews, and some of the issues identified in the written submissions prepared on behalf of the patient group represented by Levy and McRae, and also in the oral submissions made today on behalf of NHS Tayside. As a preliminary point, I wish to remind participants what the role of the ICR is. The ICR is an independent process that is independent of the inquiry. They are committed to cooperating with one another as set out in the Memorandum of Understanding. The terms of reference set out the purpose of the ICR. The purpose of the ICR is to offer and coordinate expert clinical reviews of the cases of former patients of Mr. Eljamel who wish reviews to be undertaken. The ICR will share these clinical reviews with the inquiry where consent has been provided. The ICR has made good progress with the clinical reviews. 29 experienced neurological experts sit on a panel set up by the ICR. They will undertake the reviews of former patients of Mr. Eljamel. These experts have no conflict of interest with Mr. Eljamel, NHS Tayside, or the Scottish Government. 525 former patients or family members of patients have now registered with the ICR. 489 consent forms have been received from those who registered. 77 applicant statements have been received from former patients. A substantial amount of work has been undertaken to get to this stage. The ICR wishes to extend its thanks to former patients and family members who have participated in this process. The ICR is committed to ensuring that the process is patient-centred and trauma-informed. Supports are in place for former patients or their representatives, including legal support. The Scottish Government will fund legal support for ICR participants, including for the preparation of their applicant statement. The Patient Advance and Support Service is available to assist applicants who do not have legal representation. Confidential and independent psychological support is also available from the Association of Clinical Psychologists UK. Progress has been made in the ICR, and these support systems appear to be working well. The ICR is committed to delivering its role. The ICR is working cooperatively with other parties while maintaining its independence. A timetable for the production of clinical reviews has been agreed between the inquiry and the ICR. This is set out in detail in the note prepared by counsel for the inquiry at paragraph 92. For the purposes of today's hearing, the ICR highlights that it has asked former members or their legal representatives to complete the applicant statement within 4 weeks. This is to ensure that the ICR proceeds efficiently and that the workload of the panel of experts is managed effectively. The ICR is working to the timetable. The ICR is able to achieve the goals of the timetable but this can only be done with the cooperation of other parties. The ICR appreciates that some former patients may require longer, and it reiterates its commitment to patient-centred and trauma-informed approach. However, the ICR urges legal representatives of former patients to ensure that the deadlines are complied with to ensure the smooth running of the review process. As part of its desire to work cooperatively with other parties, the ICR notes and appreciates the issues raised by the patient group represented by Levy and McRae. The chair of the ICR met with Levy and McRae yesterday to discuss these and work on a cooperative approach for finding solutions experienced by the former patients represented by it. The ICR has also considered the submissions made on behalf of the patient group insofar as they relate to the ICR. Some of the issues raised are matters for the inquiry to respond to. The notes sets out that additional information has been requested from applicant statements. It also describes delay with the issuing of revisions and comments on statements after the first draft is received. The requests for additional information come from the inquiry. The inquiry also annotates the statements with revisions and comments. The ICR is not involved in these matters and cannot address specific concerns about them. The submission made by the patient group notes a delay in the returning of applicant statements for signature. The process for signing a statement is that a signed statement from the applicants would be provided to the ICR, which would then pass it to the inquiry to apply the inquiry reference number. The ICR understands the inquiry experienced a technical issue with adding reference numbers to signed statements. The ICR was also asked by the inquiry to pause the exchange of applicant statements between 14 April and 7 May due to a change of personnel at the inquiry. Positively, the ICR understands that both the technical and personnel issues are now resolved. The submission from the patient group refers to an incident where one applicant had to sign and return a statement on several occasions. This was connected to the now resolved technical issue. The submission for the patient group also refers to medical records held by the ICR not being provided to applicants. The ICR has explained to Levy and McRae on several occasions, including yesterday's meeting, that applicants are not required to have access to their medical records to make an applicant statement. The ICR has received data subject requests from Levy and McRae for medical records, which it is endeavouring to comply with. However, disclosure is not straightforward owing to the ICR's data protection requirements. It might be helpful for the participants to understand how medical records are obtained for the ICR. The public inquiry obtains the records. These records are shared with the ICR. The ICR shares these records with the expert when instructing the review. And the only time when the ICR obtains records directly is on the occasion where a former patient has consented to take part in the ICR, but not the public inquiry. This is a very rare occurrence. There is a risk of data breach occurring from erroneous entries in the medical records. The inquiry has processes in place to prevent these breaches. The ICR does not doubt that the inquiry's processes are robust, but it cannot rely on these alone. The ICR disclosing records to the applicants requires a further screening to ensure there is no data breach. While the ICR is looking to comply with these data requests, it only has limited resource to allow it to do so. It has been suggested to Levy and McRae that these requests could be directed towards other parties. The submission for the patient group also refers to communications between the ICR and Levy and McRae. It is said that it is relatively common for the ICR not to contact Levy and McRae at all. The ICR's position is that this is inaccurate. Of the applicants invited to submit a statement, the ICR are aware of 51 being supported by Levy and McRae. The ICR can only communicate with Levy and McRae if it receives a mandate from the applicant authorising this. The ICR has so far received 23 mandates. In the case of 17 applicants, these individuals had already been invited to complete an applicant statement before the ICR received a mandate from Levy and McRae. The ICR does not have prior knowledge of whether an applicant is also a client of Levy and McRae. The lack of a prior mandate resulted in these individuals being communicated with directly instead of through Levy and McRae. In the case of 6 applicants, mandates were received prior to being invited to complete their statement. Levy and McRae have been included in correspondence with these individuals. There was one exception where an invitation was sent to the applicant only on 1 April. The ICR noted that Levy and McRae had not been included in the email, and this was forwarded on 6 April. Otherwise, the ICR's administrative team is in regular contact with Levy and McRae regarding overdue statements. Some of these are now more than 4 months overdue. Now, turning to the submissions made by NHS Tayside, it was asked whether the identities of the ICR's experts would be published. I'm not able to confirm this point at today's hearing, but instruction will be taken on this point. In summary, my Lord, the ICR has made significant progress since the last hearing, and the instruction of clinical reviews has commenced. The ICR also understands the important role which it plays in assisting the public inquiry to fulfil its terms of reference. The ICR will continue to assist the inquiry in any way it can, and does look forward to working alongside the inquiry in the future. Thank you.
Mr. Callender, thank you very much for your submissions. The final submissions that will be addressed this afternoon will be those delivered by Joanna Cherry KC on behalf of the patient and patient representative corps participants. I'm conscious of time moving on, but I'm also aware that we ought to take a break just in case further instructions require to be taken. I'm therefore going to suggest that we take 10 minutes at this time, and I'll aim to start again just after 20 to 4, and we'll hear from Ms. Cherry at that point. Thank you. Well, good afternoon again, everybody. I am now in a position to invite Ms. Joanna Cherry-Casey to deliver her submissions on behalf of the patient and patient representative co-participants. Good afternoon, Ms. Cherry. Your submissions, please.
Good afternoon, sir, and thank you. I appear with my learned junior, Ewan Scott, and we are instructed on behalf of Levy and McRae, on behalf of the patient group. We welcome the opportunity to expand upon our written response to Counsel to the Inquiry's note, particularly having had the opportunity to consider the responses from the other core participants, the independent clinical review, and the Scottish Government sponsor team. The oral submission I'm going to make this afternoon will follow the structure of the written submission we have lodged with some supplementary comments. There are 4 broad issues I want to address. First of all, timescales and deadlines. Secondly, the circumstances surrounding the delay of the Section 1 hearings set down for April-May. Thirdly, the independent clinical review. And fourthly, the constraints under which the patient group and their legal team are working. Before I do so, sir, there is a preliminary matter which I must address. And I regret that it is necessary for me to start with a statement of the gravest concern about the unwarranted attack that has been made by Counsel to the Inquiry on those instructing me today. I want to make it clear that in expressing concern about this, I have the support of many members of the patient group who have contacted Levy and McRae since this morning to express concern and in some cases distress about what has been said about their legal team. And they want me to indicate to you, Chair, that they wish to express their continuing confidence in Levy and McRae. We, as a legal team in our entirety, consider the criticisms which have been made to be both harsh and unfair. And whilst I am confident that it was not the intention of Counsel to the Inquiry to try and undermine the relationship of trust and confidence between the legal team and the patient group, because of course to do so would be reprehensible, it is disappointing that he felt it was nonetheless appropriate to proceed in the manner that he has. This is not the first time that the patient group legal team have been subjected to criticism which we consider unjustified. Counsel to the Inquiry's note contained criticism upon which we have pushed back in our response. That was our right, and the fact that further criticism has been heaped upon Levy and McRae as a result of doing so is inappropriate. Sir, as I've already indicated, Levy and McRae have received many messages of support from members of the patient group, and there is a common theme running through them, and I quote, they state that they thought the purpose of this inquiry was to investigate Mr. Eljamel, not to slate the patient group legal team. Just 2 examples, sir, will suffice of how unfair the criticism of the legal team is. The first is this. My learned friend at Counsel to the Inquiry started his submission by criticising the heading note on our written submission, which refers to this being an inquiry relating to the professional practice of Mr. Eljamel. If this is incorrect, then the inquiry itself will require to change its own internet homepage, which uses exactly the same language when describing the scope of the inquiry. Another example. My learned friend, Counsel to the Inquiry, sought to criticise the quality of the submissions the patient group legal team have lodged regarding which of the patient group might make suitable Section 2 witnesses. I can vouch, my lord, for the fact that many hours of work went into producing this document. And if my learned friend wants us to revisit this work, then he will need to identify precisely what is inadequate about it, because in framing our submission, we used the categories and guidance provided by the inquiry team. In fact, I think it's fair to say we gave more detail than they seemed to require. Finally, on this preliminary matter, sir, counsel to the inquiry felt it appropriate this morning to accuse Levy and McRae of having been discourteous in their dealings with the inquiry. Can I just say that such a statement is taken extremely seriously? It is not a characterisation recognised by those instructing me, and I can advise that correspondence will be sent shortly by a senior partner requesting specification and details of such interactions so that they can be investigated. I leave that matter to one side, sir, but I do not wish to underestimate its importance. And I turn to the first substantive point I wish to address in my oral submission, and that's the timescales and deadlines imposed by the inquiry team. They have been challenging, and in particular, the timescale afforded for our response to counsel to the inquiry's note about this procedural hearing was very challenging, as it gave us only 2 working days to take instructions from the 161 individuals whom we represent. Tight deadlines like this have been a recurring issue, and they risk compromising our ability to properly and fairly represent our clients, many of whom are vulnerable and suffer from brain injuries. Even those without such difficulties have expressed concern about assimilating the contents of such a lengthy note and giving instructions in such a short period of time. One of the patient group, who holds a very senior professional position, told us that they, and I quote, had no understanding of the content of the note whatsoever, and that they were quite sure they would not be the only one. In my submission, this exemplifies why the patient group need adequate time to consider lengthy documents in language and about procedures with which they are not familiar before giving instructions. Some of those whom we represent are not even email users and require to be sent documents by post. In my respectful submission, it makes no sense for counsel to the inquiry to compare the exercise of taking instructions from such a group with taking instructions from a corporate client in the commercial court. Such a comparison is not trauma-informed. Furthermore, in my experience, in the commercial court, it would be very unusual to be given only 2 working days to take instructions on such a detailed note. In future, sir, those instructing me would like to be afforded sufficient time to distill lengthy notes like this into a summary of key points in concise language before taking instructions from the 160 members of the patient group. And we very much hope that the inquiry team will take this into account when issuing future deadlines. Now, we note, sir, that the issue of timetabling and deadlines has been raised by other core participants, in particular the Scottish ministers and NHS Tayside. I note that my learned friend Ms Doherty underlined that NHS Tayside felt that 2 working days was a very short period of time in which to take instructions on counsel to the inquiry's note. Of course, they are a corporate client, unlike the clients I represent. In this connection, we would like to associate ourselves with the requests for earlier disclosure of material relevant to the September hearings, earlier notification of the witness list and timetable, and a recognition that deadlines which clash with the beginning of the Scottish school summer holidays in July may need to be reviewed. I now move to the second matter, which of course is the reason we are here today, and that's the circumstances surrounding the delay of the Section 1 hearings, which were set down for April-May, and the fire safety issues with the hearing suite. I'd like to break down this aspect of my submission into 3 parts. A relates to the reasons for the delay. B relates to the engagement of the patient group's legal team regarding these circumstances. And C relates to the question of when evidence is to be taken from NHS Tayside about the destruction of logbooks last autumn, notwithstanding the do not destroy order. So if I may turn to point A. the reasons for the delay. We are grateful to counsel to the inquiry for the information in his note, and we note that the Scottish Government have been aware of a fire safety issue with the hearing suite since at least December 2025. We are therefore very disappointed that it is taking so long to address matters adequately. The degree of distress and the loss of trust in the inquiry process that has been occasioned among members of the patient group by these circumstances and the delay of the April-May hearings should not be underestimated. The patient group are very concerned that following their long campaign for a public inquiry, assurances given to them by the Scottish Government to the effect that the public inquiry would be patient-centred and trauma-informed are not being honoured. As we have heard, one member of the group has learned from a Freedom of Information request that fire safety issues currently preventing the use of the hearing suite may have been in existence since the venue was originally selected. We've passed the information she recovered, which we ourselves only received on Monday, to the inquiry for investigation. We were also concerned to know exactly what consideration had been given by the Scottish Government to other potentially suitable venues, including hearing suites, which had been fitted out for other recent public inquiries, which are now finished, such as the hospital's inquiry in Edinburgh. Our understanding, having read counsel to the inquiry's note, was that no other suitable venues were available. We were therefore very surprised to read that the Scottish Government-sponsored team submission appeared to suggest that 2 alternative venues already fitted out as hearing suites for other public inquiries were offered by the Scottish Government, but rejected by the inquiry team. Clearly, this contradicted what was said by counsel to the inquiry to the effect that no suitable alternatives were proposed by the Scottish Government. I've heard what's said today, and all I can really say in response is that the patient group would like to be clear whether alternative venues have been proposed and considered, if so, which ones and why they have been rejected. I think we have a little more clarity about that today, but I'm not sure that the patient group would consider it sufficient. And I stress that this sort of clarity is vital to restoring trust in the process. Now, I noted that my learned friend, Mr. Duncan, who appeared for the sponsor team, said that the Scottish ministers cannot give assurance that the hearing will be able to proceed in September. And I must stress that it is a matter of the gravest concern to the patient group that there might be any further delay because of the non-availability of a suitable hearing suite for the September hearings. It seems, from reading the sponsor team submissions, that the issue that has been arisen could be rectified by some internal construction works and a retrospective building warrant or a completion certificate. I've heard what more has been said about that today, but given the proximity of the September hearings, I wish to seek reassurance that this can be done in time to let those hearings proceed. Sir, it needs to be understood that at least some of the patient group had rearranged their professional and personal lives to attend in April, May, and will likely do the same for September. It causes huge inconvenience as well as distress if hearings are cancelled at short notice. Moving on to section 2B of my submission, this relates to the engagement of the patient group's legal team regarding the circumstances surrounding the delay. Counsel to the inquiry has provided a number of observations about the chair's decision-making process in delaying the commencement of the section 1 hearings, at paragraph 26 of his note. And whilst we would not seek to presume what factors were relevant to the chair's decision-making process in this regard, we consider it necessary to address the implication that paragraph 2G of the note that there was no engagement from Levy and McRae on behalf of the patient group on the preferred approach to the hearings. We completely refute this, and here is why. On 6th March 2026, we received correspondence from you, sir, advising that an issue relating to building safety matters had arisen. As a result, the hearings that were to take place over the scheduled period would need to be held remotely. We understood that the only individuals that would be permitted to attend said hearings would be the inquiry team, witnesses, and the witnesses' legal representatives. We immediately realised that given the proposed list of witnesses for the hearings, this arrangement would most likely permit witnesses from NHS Tayside and their legal representatives to be physically present when giving evidence about the destruction of theatre logbooks, while the patient group and their legal representatives would not be physically present. The dismay this caused to members of the patient group should not be underestimated. As I said, many have campaigned for this public inquiry for years. Many have also lost trust in NHS Tayside as a result of their experiences at their hands. That loss of trust has been further exacerbated by the revelation that vital records had been destroyed last year, despite the existence of a do not destroy order. The patient group understood that evidence was to be taken from NHS Tayside witnesses about the circumstances in which such books had been destroyed, and understandably, many wished to be physically present to hear that evidence. Their concern was further exacerbated by the fact that the information that some core participants were going to be able to be present, but not the patient group, that information was not in the public domain. That meant that they were prevented by the confidentiality requirements of the inquiry from discussing the full nature of their concerns with their parliamentary representatives, or otherwise publicly ventilating the full nature of that concern. By correspondence dated 13th March, the patient group's legal team raised concerns over that discrepancy, by which I mean the discrepancy between the information provided to the public and what had been communicated to core participants. Given the limited amount of information provided about the issue, the patient group's legal team requested a short procedural hearing at the earliest possible opportunity so that the issue might be addressed openly and transparently. By correspondence dated 18th March 2026, you, sir, wrote to the patient group's legal team refusing the request for a short procedural hearing due to a lack of clarity over its intended purpose. You, sir, further requested whether there would be support within the patient group for, firstly, limited Section 1 hearings with remote participation, including the matters referred to in the letter of 6 March. Secondly, some further limited version of those hearings. Or thirdly, postponement of the Section 1 hearings altogether until the building issue had been resolved one way or another. A response to these queries was requested within 24 hours. The patient group's legal team responded on 20th March within that deadline, stating that it was not possible within the timescales imposed to discuss and thereafter take instructions on the proposals put forward from the group, which includes 161 individuals with diverse views. Further, it was highlighted that there was currently insufficient information available to permit any such instructions to be fully informed. A request was made for further information, particularly as to the stage of the inquiry's preparedness and what was meant by a further limited version of the hearings. A consideration which weighed heavily with the patient group's legal team was the need to avoid the patient group finding themselves in a position where any delay might be laid at their door or said to have been at their request. We consider this to have been a reasonable apprehension, particularly as it was our impression that the inquiry team were not fully ready for the Section 1 hearings as we had not received a formal witness list, timetable, or indeed any disclosure. The request for a short procedural hearing to address the same was reiterated and again refused. Now, I make this full explanation in the hope that it will demonstrate that the patient group's legal team proactively sought to engage with the inquiry in respect of the proposals regarding the Section 1 hearings. To suggest or imply otherwise is inaccurate, unhelpful, and unfair to both the patient group and their legal team. With all due respect, it is not for counsel to the inquiry to tell the patient's legal team how to do their job. I should add, however, that the patient group are grateful to you, sir, for arranging this procedural hearing. It allows me to make our position about what occurred crystal clear, and I trust it will be carefully noted. It has been most unfortunate that to date, only partial information has been in the public domain, and that the reasons for the patient group's concerns might therefore not have been fully understood. Now, I turn very briefly to point 2C, which relates to the question of when evidence is to be taken from NHS Tayside about the destruction of the logbooks, notwithstanding the do not destroy order. I say I turn to this briefly because I'm grateful to the clarification that counsel to the inquiry gave us this morning that this will be happening at the Section 1 hearings in September, provided they proceed. And that brings me to my third point, which relates to the independent clinical review. I would like to preface what I have to say about the independent clinical review by reminding the inquiry that from an early stage, Levy and McRae have raised concerns about the independent clinical review timetable and methodology. These were reiterated both at the preliminary hearing and in our opening statement. It should not be forgotten that at the beginning of September last year, on their own initiative, Levy and McRae convened a roundtable and invited the inquiry team, the independent clinical review, and the Scottish Government to discuss their concerns about the way in which the independent clinical review was to be conducted. That meeting took place, and we were grateful to the independent clinical review and the inquiry for attending. The Scottish Government did not attend. And at that meeting in particular, concerns were raised by those instructing me that medical records recovered by the inquiry and made available to the independent clinical review were not to be made available to the patient group or their legal team, notwithstanding that they referred to members of the patient group. So I say that by way of background to what I'm now going to say. At paragraph 92B of his note, my learned friend counsel to the inquiry alleges that, and I quote, "It has become apparent that the legal support being provided by Levy and McRae appears to have been a source of delay." We feel that this suggestion is unfair and it is refuted. The reasons why are set out in detail in our written submission. I do not have sufficient time to go through them in detail now, but I do adopt the submission, and I'd like to summarise them as follows. While Levy and McRae acknowledge that they have not met some of the timescales set for completion of the independent clinical review statements, they do not believe that these timescales have been realistic or trauma-informed. And they say this having regard to a number of factors, particularly considering the length of time that has passed since patients were treated by Mr. Eljamel, the complex medical information that is requested, the detail that is requested in terms of names and treatment dates, the vulnerability of the witnesses, and the issues with data protection, document management, non-availability of medical records, and evolving procedures, which Mr. Callender addressed in his submission. Neither the independent clinical review themselves nor the inquiry have met their own timescales for review and return of statements, and it took a long time to get the process off the ground. The fact that Levy and McRae have been singled out as a source of delay in these circumstances is, in my respectful submission, simply not fair. I should say, my lord, that those instructing me, as Mr. Callender said, have had the benefit of a meeting with the independent clinical review, and I think there have been some very constructive discussions, and I'll come back to those in a moment. Counsel to the inquiry has further observed at paragraph 92B of his note, and I quote, "Many draft applicant statements for which support has been provided have not achieved the quality that both the inquiry and the ICR would have expected. To ensure the important contribution from applicants is achieved, an explanation is also requested." Well, here is the explanation. As counsel to the inquiry will no doubt be aware, the applicant statements are not precognitions. The guidance provided by the Scottish Government in respect of the independent clinical review notes as follows, and I quote, "The applicant statement is the document that provides the opportunity for former patients or their authorised representative to describe in their own words their experiences and concerns in response to specific questions relevant to the remit of the ICR. And I emphasise the fact that it's supposed to be in their own words." The amount of support from Levy and McRae to produce these statements varies significantly across the patients, with some preparing statements themselves and asking for input and advice on specific issues, compared with others requiring support to transcribe the responses to each individual question. Levy and McRae provide their clients with a collaborative approach to the completion of the applicant statement, which offers choice to their clients as to how they wish to provide their evidence, in keeping with a trauma-informed approach. At all times, in light of the stated purpose of these statements, Levy and McRae seek to record their clients' own words. That is the nature of the statement, and it should be expressed in those terms. In light of the differing levels of support requested by the applicants from Levy and McRae, and the unwillingness to provide the associated medical records to the applicants or their legal team, it is concerning that the inquiry seeks to criticise the quality of the applicant statements. Many of the applicants are disabled and continue to experience significant pain. They often rely on pain-relieving medication which affects their memories and ability to engage with this demanding process. To criticise the quality of the statements provided in those circumstances demonstrates a fundamental lack of understanding of the individuals who are being asked to complete these statements, and it is not trauma-informed. And in this connection, we note that the inquiry's trauma-informed policy is not yet in place, and we feel that the sooner it is in place, the better. Finally, under this heading, under reference to paragraph 92E of this note, we fear that my learned friend counsel to the inquiry has proposed an unrealistic timetable for the completion of the remaining ICR statements. This is particularly so when Levy and McRae are in the majority of cases entirely dependent on the applicant contacting them to advise that they've received the request. They have requested on numerous occasions that the ICR advise them when such statements have been issued. On several occasions, the ICR have been provided with a mandate on behalf of the individual concerned, authorising them to liaise directly with Levy and McRae. And notwithstanding this, it remains relatively common for the ICR not to contact Levy and McRae at all. Now, given the issues experienced with the ICR to date, some of which are noted in the written submission, the timescales that I've suggested are, we believe, wholly unrealistic, and we would also query whether they are trauma-informed. Now, as explained by Mr. Callender, who represents the ICR, Levy and McRae met with Professor Wigmore yesterday to discuss aspects of the proposed timetable which they find most challenging. and I understand he has expressed an appreciation of their concerns. Likewise, we have taken on board the concerns expressed by Mr. Callender today and will look into them. For example, the issue of the mandates. The number of mandates mentioned by Mr. Callender does not accord with the information that I have, but that will be checked carefully. And really what we're interested in doing here is having a collaborative approach with the independent clinical review. And we are very grateful for their collaborative approach. And I'm afraid to say we have to contrast it with the approach of Council to the inquiry today. That being said, Levy and McRae are very happy to have further discussions with the independent clinical review and the inquiry team with a view to moving things forward as regards the excuse me, independent clinical review. And that brings me to my fourth and final point. And that relates to the constraints under which the patient group and their legal team are working. Now, I've already mentioned, Chair, the need for the inquiry to impose deadlines which take into account the fact that the patient group consists of 161 individuals from whom their legal team must strive to take instructions, and that group contains people with significant vulnerabilities and disabilities, and not all of whom have digital access. So they really are in a very different position from the other core participants. And in my respectful submission, this ought to be taken into account. These are all no doubt matters which the inquiry's trauma-informed policy will address when it is in place. But in the meantime, I hope the reasonable concerns which I have articulated today will be noted and acted upon. Finally, in relation to this point, at paragraph 55 of his note, my learned friend counsel to the inquiry referred to a generous full-time funding award having been made to the patient group's legal team for work to be carried out in relation to this public inquiry, and he has done so again today. In the interests of clarity and transparency, we would wish it to be understood that neither we as counsel nor those instructing us are being paid full-time to represent the patient group. Instead, in accordance with the inquiry's protocol, we submit proposed fees for particular pieces of work on a monthly basis. The proposed fees are then subject to close scrutiny by the solicitor to the inquiry, who carries out an assessment and has the right to refuse to honour them in full. Fees have been issued for work carried out by the patient group legal team in August, September, October, November and December of last year, and January, February and March of this year. So far, none of these fees have been assessed or paid, apart from those relating to the month of August 2025, which covered a period of only 2 weeks' work. We note that the inquiry's costs to date are 2.8 million. It should be understood that only the tiniest fraction of this sum has been spent on remunerating the patient group legal team. If, as was suggested earlier, lawyers are making money out of this inquiry, it's certainly not the patient group's legal team. And I must emphasise that the fact that the legal team are not engaged on a full-time basis is an important factor in appreciating the difficulties encountered, particularly by counsel, in responding to the inquiry's tight deadlines. Notwithstanding all of this, I note that my learned friend, counsel to the inquiry, states at paragraph 55 of his note that patients have contributed significantly to the inquiry's work. We were pleased to read this, and we see this as a tribute to the resilience of members of the patient group, as well as their legal team. But the constraints under which both are operating must be properly recognised. As my learned friend who appeared for NHS Tayside has underlined, this inquiry is not an adversarial process. Rather, it is founded on principles of collaboration and cooperation. I regret to say that we do not feel what has been said about Levy and McRae today is in the spirit of those principles. Trust in this inquiry process and a meaningful contribution on the part of the patient group will not be achieved by unjustified attacks on their legal team. I hope this will not happen again, and that an apology to Levy and McRae and those whom they represent will be forthcoming. Thank you, sir.
Thank you, Mr. Cherry, for your submissions. Now, Mr. Dawson, I'm conscious that it's now after the appointed time when we were, well, not quite, but we're not far short of the time when we would be due to finish. And a lot of what has been said, both before lunch and after lunch, contain matters that will no doubt be capable of being dealt with in the course of subsequent correspondence in the usual way. And I refer not least to matters relating to timescales and deadlines that have been touched on this afternoon. But if there are any particular points that you briefly want to come back on.
So I think there are a few matters on which I could usefully provide some further submission. First of all, in relation to the submission made by my learned friend Mr. Duncan on behalf of the Scottish Government as sponsors, I'm obliged to Mr. Duncan for the no doubt short period of time he had to take instruction, in particular seeking a consultation to provide as much clarity as he possibly could today. It will not surprise him, perhaps, to learn that the sum total of what he has told us is somewhat reminiscent of a number of other representations made to the inquiry by the Scottish Government sponsor team before. I recognise and appreciate that there is a plan, as I understand it, for us to receive in writing a plan for the Waverley Gate site, a plan for what's called Plan B, the possibility of an alternative venue, a written explanation, as I understand it, about whether the inquiry could have, the Scottish Government could have undertaken further vetting of the venue before December 2025, a written response in relation to confidentiality undertakings. As far as that written response is concerned, it would, I think, be interesting to hear from the inquiry sponsor team as to how their position with regard to confidentiality undertaking sits with the approach apparently taken on behalf of the Scottish ministers in their response capacity, as highlighted by my learned friend Ms Thompson in that capacity. Sir, I should also say that in the submission made with regard to confidentiality undertakings, the focus, if I may say so, was on confidentiality undertakings being provided by Scottish Government employees who are staff within the inquiry. That is a matter which is largely historic, and it would be of assistance if the written submission which we are to receive from the government focused on the provision of undertakings by other staff working within the government with whom the inquiry requires to interact. Sir, Mr. Duncan raised the question as to whether, with regard to recruitment, there were then any outgoing matters with which the inquiry could assist, with the Scottish Government could assist. There are, in light of the fact that, as I clarified earlier, there are a number of vacancies within the inquiry at present, which is a matter which appears to have been lost in translation between the two organisations. What we are looking for, given that the main issue which we've experienced relates to delays relating to onboarding staff, is a commitment, as I said earlier, that will be achieved as a matter of priority for the inquiry in a matter of days, as opposed to in a matter of weeks, which has been our previous experience. As I've said, sir, the suggestion that matters will be addressed urgently is one which I, and no doubt the patient group at least, if not others, will address with a degree of scepticism. It is important to note, as my learned friend Ms Cherry has pointed out, that the enforced postponement of the inquiry hearings has caused a significant amount of anxiety, which is expressed in detail in her written submission and has been expressed again today. Any ongoing delay will no doubt only exacerbate that, in particular as I hope has been appreciated by them, a significant amount of work has been put into rearranging those hearings, both for September and the Section 2 hearings in December. It has been your practice, sir, to seek to publicise information about this important matter, and no doubt if there are failures in response within the next week or so, that will be a matter which you will consider publicising in order to keep all parties on this important matter sufficiently appraised. There are a few matters which I would like to address from Ms Doherty's submission on behalf of NHS Tayside. First of all, she raises a point which was echoed by Ms Cherry in her written submission, which I think the patient group has adopted, with regard to the date which is proposed for the sharing of witness list, a proposed witness list with core participants for their comment for the Section 1 hearings, that being the 6th of July. I have two matters to address in that regard. The first is that that date relates to the sharing with core participants in general for their input on the proposed list. The individual witnesses themselves would be communicated with before that date, which I think deals with the point that Ms Doherty has reasonably raised about the need for executives who may be giving evidence at those hearings to arrange to be available to do so. It is, I think, a point which is fairly made on her behalf and on behalf of the patients by Ms Cherry, that we may, in fact, be able to look at the date of the 6th of July again in order that an earlier intimation of the witness lists can be undertaken. As I say, I think that will be achievable, and we will go away and have a think about when that can be done and obviously intimate that to core participants. Another matter which was raised by her relates to the timings and activity related to the legal support issue being resolved. It is disappointing, I have to say, that Ms Doherty sought to be critical of the inquiry's engagement on this issue. I should say, contrary to her recollection, it was not in fact NHS Tayside that brought the legal support issue to the table, but it was in fact the inquiry itself in the Council to Inquiry note before the preliminary hearing. The reason that that was done was based on difficulties which I was aware had been experienced with this issue in previous inquiries. It is ironic that Ms Doherty should complain about the need to deal with this hearing and also the minor amendments which are being pursued in connection with the NHS Tayside statement at the same time this week, when she, it would appear, does not understand the amount of work that the inquiry team has had to deal with in recent months, as has been outlined in the submissions made today. Although it is fair to say that the legal support issue does need to be resolved, as is reflected in our written materials, it is a matter which will only raise its head in connection with the Section 3 hearings, during which we intend to hear from medical professionals. It is therefore not as current an issue as the ones we have been dealing with in recent months, and I'm sure she will understand that there have been more pressing issues to address. The suggestion that this is a matter which should have been raised before today, it is correct to say that she asked me to raise matters between us rather than raising them at this procedural hearing. It is a matter for the inquiry to decide how this issue should be raised. It is clear that there is a significant public interest in this matter. She herself has indicated in the past that she is keen to hear from the patient group as to their input, and therefore it was thought appropriate that this matter should be raised at this hearing. It is, as I think she accepts, also the case that there has been an evolution even in the most recent iteration of her proposals, in particular relating to the possibility that representation may be paid for. I have expressed the view, sir, that that matter hopefully will be able to be resolved, and that you should write to the representatives NHST side expressing any views you have on the matter and any stipulations which the inquiry still wishes to insist upon to make sure things work smoothly within the inquiry's processes. Ms Doherty also raised the point which was addressed by my friend Mr Callender briefly, only I think to say that he required to take instruction on it with regard to the names of the ICR witnesses. The ICR note helpfully confirms that there is now a relatively large bank of neurosurgical witnesses who have been engaged by Professor Wigmore, and indeed a number of them are working on neurosurgical reports as we speak. It will, in due course, through the inquiry's processes, become apparent who these individuals are. The inquiry, as I've said before, are gathering CVs of these individuals, and it will be apparent who they are when their reports start to filter through the inquiry disclosure process. As regards matters, I have nothing to add on the contributions made by Ms Thompson, other than what I've already said, or Mr Callender. There are a few matters which I can address, I think, helpfully in connection with matters raised by Ms Cherry on behalf of the patients. As I've already said, we will take on board her suggestion and that of Ms Doherty that we may be able to issue the timetable at an earlier date, which I think deals with the point made by others about clashes with summer holidays. She sought greater clarity, which I thought had been provided already by various parties, including Mr Duncan and myself, about the position with regard to alternative venues. The ambiguity within the Scottish Government sponsor submission, I think, was accepted by Mr Duncan. That may not entirely help the patient, so I'll try to be clear on the matter. As far as alternative venues were concerned, the hospital's inquiry venue has never been available to this inquiry for its use at the time of the hearings in April or May. It was mentioned in passing in discussions only to discount it as an option on the basis that the Scottish Government currently holds no lease over the property, that having come to an end in connection around the time of the end of the hospital's inquiry itself. As I pointed out earlier, as I understand it, there may in fact be efforts for other reasons for the Scottish Government to try to get a lease over the property again, but that's not something about which we have any further information, and it's certainly not been suggested that that would be a venue which would be available either for the hearings which have been postponed or for the hearings which we plan later this year. As far as the possibility of an alternative in the Scottish child abuse inquiry venue, this is bound up with the earlier discussions with Mr Duncan about the Plan B. As I set out earlier, that has never been offered to the inquiry as an alternative venue, and the recent correspondence I referred to between the head of the Scottish Government sponsor team and the secretary to the inquiry makes clear that it is currently the position that a Plan B is being worked up as part of a written submission to be put to the inquiry. Therefore, we have not at any time been offered the possibility of an alternative venue by the Scottish Government. It appears, helpfully, that work in that regard may be ongoing at the moment, and of course the inquiry will consider that for its future hearings as and when it is received. I've already said that you anticipate, no doubt, sir, that that will be received in early course. Ms Cherry, I think, also asked for an explanation with regard to the possibility of other alternative venues in order to try to deal with the position in which the inquiry had been placed by the government. The inquiry team itself started to look at other venues. A number were looked at, none were proven to be suitable. As I said earlier, sir, the complexities which are apparent from the narrative given by the sponsor team about matters such as safety in walls and the like reflect, I think, the difficulties which exist in procuring an appropriate venue to hold a public inquiry in which large numbers of members of the public will attend. It has therefore been your position that you have sought to rely upon the Scottish Government and its expertise in these matters within its property department to do that on the inquiry's behalf. Despite that, efforts were made internally to try to find other venues. No suitable venue was found, in particular with regard to the short timescale available to us in advance of the April and May hearings. Further efforts have been made with regard to trying to locate something for later this year, and unfortunately those have also hit a dead end. So hopefully that clarifies that. One further matter I think that I can clarify is the submission made by Ms Cherry in connection with paragraph 2G of the submission of the Council of the Inquiry note. This is the one which says core participants were consulted about the preferred option for the hearings. The views of those who responded were taken into account by the Chair in reaching his ultimate decision. Though no submission about the preferred approach to the hearings was received from Levy-McRae on behalf of its core participant clients, the inquiry took account of the views of some of them expressed via the media, social media, and elected representatives who contacted the inquiry to express their constituents' views. I can perhaps clarify, as I think is accepted, that what I was referring to in that passage relating to there being no submission about the preferred approach relates to the letter which has been produced, which was sent to you, sir, by Levy and McRae, in which they indicated that they had been unable to take instructions on the options which were put to them, no doubt as a result of the short timescale which we would accept had been imposed upon them. The point which I was seeking to make there, sir, was that despite the fact that Levy and McRae had been unable to do that, you did hear the voices of patients in your decision-making on the basis that they had been publicly expressed via the media and social media, and of course you had also received correspondence from a number of their elected representatives expressing their position. The point I was wishing to make, therefore, was that despite the fact that Levy and McRae had been unable to make that submission within the time available to them, the voices of patients were certainly heard in the decision-making process, and they continue to be. Thank you, sir. I have nothing further.
Thank you very much. Well, can I address myself once again to all who are connected to the hearing as Mr. Dawson's remarks now bring to a conclusion this procedural hearing. I am grateful to all who were involved in preparing and delivering the submissions presented before me today. And I don't underestimate the amount of work required to make those submissions and to deliver them in the way that was done during the course of the day. The requirement to have this gathering primarily arose from the postponement of the introductory hearings and the need to address the understandable expectation of many interested parties that they should not now be long delayed. I reiterate publicly that I attach the utmost importance not only to public engagement with the inquiry, but also public attendance at its hearings. The offer to hold Section 1 hearings with remote public attendance was motivated, I assure you, by the best of intentions. But the swift, immediate and understandable concern with which that offer was greeted simply serves to underline the importance of what must now be a default position going forward, namely that substantive hearings must take place in a location to which the public have safe access. I can assure you all that I never wished it to be otherwise. I am determined that, if at all possible, the Section 1 hearings should take place at the time discussed by Mr. Dawson this September. As you will have heard, it is and has been my inquiry team's intention to use the time afforded by the otherwise unwanted postponement to enhance the content of the Section 1 hearings and you are aware now that we have earmarked additional hearing time to enable that to be done, and are generating our plans accordingly. But this hearing has also identified other practical and communication issues associated with the inquiry's operations, which merit careful consideration and reflection. I appreciate that working within the public inquiry sphere can present significant professional challenges to those involved. This inquiry is no exception. No doubt, this is significantly driven by the non-adversarial nature of the exercise on which I am embarked, and that is a point that has been mentioned a number of times already, but also the vital importance of the subject matter of the inquiry, the width of its terms of reference, and the delicate balance that I must reconcile between the interests of speed and of thoroughness. That balance has often been referenced during the course of submissions today. Mr. Dawson alluded in his submissions to certain lessons that might be learned from the process to date and how they might be taken forward. Let me supplement his remarks with the observation that my inquiry team can only meet their onerous responsibilities with the support and cooperation of all of you, representatives and represented alike. As has been mentioned already, but I endorse it, this isn't and should never feel like an adversarial process. Put shortly, our aims are one and the same: to exhaust the terms of reference set by the Minister within a reasonable time and at reasonable cost. May I therefore, as ever, encourage recognised legal representatives, as well as those whom they represent, to move forward with my team in a positive and collaborative spirit in fulfilment of those aims. The building issues will be overcome, and we are now entering the evidential stage of this inquiry, and you have my commitment, and that in that same spirit we will reciprocate. It only remains for me to reiterate my thanks to you all, in whatever capacity you have joined the hearing, for the interest you continue to show in our work. A number of matters that have been raised can conveniently be dealt with in correspondence hereafter, and I trust we will meet again soon for the conduct of more substantive business. Meantime, however, this hearing is now adjourned.